A case in Toronto could set a precedent for other disputes about vaccine mandates in the workplace. A Labour arbitrator recently ruled that the City of Toronto's vaccination policy for firefighters is reasonable, but the way the city has enforced it by firing those that refused was not. Employment lawyer Alex Lucifero joins us now. Alex, we've been talking about this and waiting for decisions like this. So let's talk about this ruling and the possible influence that it's going to have on other cases that haven't been decided yet. What do we make of it?
Yeah, well, certainly it's going to stand as a precedent. And in my opinion, actually, I think a well-reasoned precedent, Matt, in exactly the way you just described, which is the arbitrator in this case effectively found that a dismissal for cause, meaning a termination from your employment without any notice whatsoever, without any severance whatsoever, was an unreasonable action on the part of an employer on behalf of employees that have been let go for not abiding by a vaccination policy. It's something that we have been talking about for months, as you'll probably recall, Matt, and that we've been warning employers about for as many months, in that, a termination for cause is ultimately the most drastic step you could take in the employment relationship, reserved for the worst of the worst offenses. And it's very possible that not abiding perfectly by a vaccination policy doesn't rise to that level of cause.
So do we again, and where what you've just explained, the ripple effects now, as this could kind of move through, other employees, whether it's outside of just Toronto firefighters in general, if they've been terminated for cause as a result of the mandatory vaccine policy, can they expect to have severance? Do they have some recourse now?
Well, certainly in the unionized environment, those unions that have taken up grievances against their employer, those employees would actually have a right to their jobs back. Interesting. They would have a right to reinstatement and for repayment of lost wages during that time. I mean, that could be a considerable amount of money if they've been off of work and terminated for an extended period of time. In the non-unionized environment, Matt, employees would be owed severance pay. Severance is based on an employee's age, position, years of service. The longer they've been with that employer, the more senior, specialized their position is. The older they are, the more severance they would be entitled to. Of course, this is always a case-by-case factual analysis. It really depends on the industry that the employee is in, the nature of their work, the nature of the employer. Those are the options that employees would have.
Okay, certainly, again, we're going to keep an eye on this, and we'll talk, as I'm sure there's going to be more cases that get decided. Alex Lucifero, always appreciate your insight. Thank you for this, sir.
Thank you.